Good morning, ladies and gentlemen. Our first case for argument today is United States against Matthews. Mr. Kelleher.
Good morning, Your Honors. Christopher Kelleher for Monty Brannon. Mr. Brannon has raised 7 issues on appeal. The leading 4 concern sufficiency of the evidence. Recognizing...
That leads to my first question, Mr. Kelleher, which is where can we find the district court's ruling on the sufficiency of the evidence?
Your Honor, there was no published written opinion.
There were at least 2. Some of them are cited by the government's brief, although the government did not attach them. The district court spent the first 20 pages of the sentencing transcript discussing this issue. Our Rule 30 requires that to be attached as an appendix to your brief. You have certified to this court that you complied with that rule. You transparently did not. We found 7 rulings of the district court that are attacked here, not a single one of which is in the appendix to your brief. How did that happen?
Your Honor, I apologize to the court.
Making a false certificate to a court is more than a matter of apology, counsel. You don't misrepresent things to a court.
Yes, Your Honor. And I would say that it was a misstep on my part because there was no written published opinion.
Our rule is crystal clear. It was amended more than 20 years ago to make it clear that the requirement includes discussions in transcript. It's not limited to published opinions. Is there some ambiguity in the rule that confused you?
No, Your Honor.
Then why are you saying, well, there's no published opinion? The rule is crystal clear.
Yes, Your Honor. And again, I made the mistake, and we should have, myself, my co-counsel, I take full responsibility for not including the transcripts.
Please proceed.
Thank you, Your Honor. As to the sufficiency of the evidence demonstrated that Mr. Brannon was essentially a silent partner. Mr. Matthews was the puppet master. He pulled the strings, and any authority that Mr. Brannon might have had was simply nominal.
What about this loud discussion that resulted in the $7,500 check to Brannon afterwards?
Certainly, Judge Brennan, that could be construed as demonstrating Mr. Brannon knew something was up, but we would have to essentially speculate as to what transpired in that conversation. Obviously, there was no testimony from either defendant or a third party or a third witness as to what transpired in that discussion. But admittedly, the timing does look a bit suspect. I would concede that point. Additionally, when you look at the timing, and the context here is critical, Mr. Brannon did not come into the picture until essentially 3 years later, after other investors had been involved, after the project had started. So in essence, we would assert Mr. Brannon was, to some degree, a victim as well. 3 years into the project, it was already having problems. Mr. Matthews was already having financial issues, and essentially Mr. Brannon was a lifeline. His $1 million investment in July of 2011 was a lifeline to this project. So Mr. Brannon, in a lot of ways, again, not to dismiss some of his involvement, but in a lot of ways he was a victim as well.
Well, he entered the scene, at least as I can figure it out, and call it about July of 2011. Does that seem fair?
That's correct.
That's when he invested in GEM, as everyone's calling it?
Yes.
Okay. But the activity for which he was found criminally responsible, really, it's like 2016, 2017. So he's part of a business enterprise with Mr. Matthews for about 4 or 5 years, right? Including sharing office space, attending meetings where checks are signed, and the like. So I thought you might make the timing argument, but there's a lot of time that passed.
Certainly, Your Honor. And Judge Scudder, we recognize that There was a substantial amount of time between 2011 and 2016, but again, I think the plan was set in motion prior to that, prior to Mr. Brannon coming on, and that's what I think makes this case a little bit different, a little more unique than some of these typical cases, because again, Mr. Matthews had set his plan in motion. He was already treading water. He was already shifting funds around, needing money, and therefore Mr. Brannon coming in when he did, again, he was a lifeline, but also Mr. Matthews essentially didn't change his modus operandi. He was continuing to shift funds, continuing to lure investors, continuing to keep...
But after that meeting that Judge Brennan referred to, where there were raised voices or table pounding or whatever happened there, Mr. Brannon started to receive checks, right? Checks that were sent to his enterprise, Brannon and Company, diverted away from the creditors at that point in time, or at least couldn't a reasonable jury have so construed the evidence?
They could, Your Honor, on some of these checks. But again, I would point to the context overall on some of at least the mailings, let's say, to lenders on some of these counts. Again, that Mr. Brannon, his impact was, I would say, was non-existent, because again, Mr. Matthews was continuing his trend of misleading or at least keeping lenders and investors in the dark. I see I'm in my rebuttal if there's no further questions. Thank you, Your Honors.
Thank you, counsel. Mr. Breedlove. Mr. Breedlove, I have the same question for you. Where do we find the district court's rulings in the appendix to your brief?
You do not, Your Honor. I failed in my obligations to the court, and I failed in my certification. That much is clear from the previous question.
Well, it's not a question of failing. It's a question of lying. If you lie to a federal court, there are consequences.
Understood, Your Honor.
Did you even read Rule 30?
I did, Your Honor.
Then how can such a thing happen? One of the pieces of Rule 30 is, and I quote, "If the appellant's brief challenges any oral ruling, the portion of the transcript containing the judge's rationale for that ruling must be included in the appendix." And you certified that you had done that.
That is correct, Your Honor.
Well, there have to be consequences.
Understood, Your Honor. The government, in its closing argument, Your Honors, refers to the case as something that reads like a book. And they refer to all the sections of the book. In their indictment, the largest section of their book, covering 9 paragraphs, is about the side letter agreement. The side letter agreement is referenced during the trial over 275 times. By my count, it's about 283. The court refers to it as one of the most important theories of the government's case. Despite all of that, the court's ruling preventing us from putting on information about whether or not the side letter agreement was valid leaves the jury reading a Cliff Notes version of the book. They don't have the full story. Our justice system, the foundation of it, the foundation of the jury, is ensuring they get the correct instructions and all of the evidence.
Mr. Breedlove, give me 30 seconds on the story of the side letter agreement. I know what it is, and I know why, or I think I know from the briefing why it was executed or why the city wanted it. What I can't understand from the briefs is how it connects to a theory of defense.
It connects to a theory of the defense in 2 ways, really, Your Honor. The first is that it's central to the government's argument. Okay? They reference it so frequently, and they try to conflate throughout the trial.
Yeah, just go to this content of it. I know it's talked about a lot, but there's not a lot of context given as to why Mr. Matthews thinks it's somehow exonerating. That's what I don't understand. How does he think that the side letter agreement, exonerates him from these fraud convictions?
Part of the alleged fraud was breaching that contract, Your Honor.
Right, diverting money away from creditors.
But part of the evidence was also that they were signing false certificates and those sorts of things related to the side letter.
Okay.
And that was a lot of the evidence, and that they weren't allowed to do those things as a result of the side letter. And so the rules of the game that the jury were told were that one of the rules they have to follow is the side letter. And they were being told, in evidence that didn't come in because it ended up being barred, by attorneys that it may not be valid. They had bankruptcy trustees that thought they had claims against the city. And so when we have this contract that is such a central tenet of the government's case, it's the most important chapter of their book, and we don't allow the defense to talk about why it might not be valid, that's what
Why
that
the side
information
letter
would-
might not be a valid agreement?
That's correct, Your Honor. And if it's not a valid agreement, the mens rea and what the jury would interpret from the breach of it is going to be potentially different.
Okay. I got another question for you. There's some references in the brief. I had a hard time connecting the dots here. There was either a lawsuit filed by your client, maybe Mr. Kelleher's client too, or a lawsuit threatened against the city of Peoria. You know what I'm talking about?
I do, Your Honor.
Okay. And there's arguments in the brief about how, or contentions that the district court committed error by not admitting into evidence the complaint or a draft complaint or something.
That's correct.
What's going on with that?
There were lawsuits against the city back. It was a very litigious in civil court situation. One of the
But what is the alleged error that the U.S. district judge should have admitted into evidence just a civil complaint? Is that what's being challenged on appeal involving this complaint?
that the complaint and all of the circumstances around it should have been allowed in. Again, it's one of the chapters of the government's book is the civil lawsuit, and in the indictment, the government complains that part of their scheme to defraud was continuing things out by filing for substitutions
But
of
what
judges.
I don't understand about that is how does the existence of a civil complaint go to whether the government proved the elements of mail fraud beyond a reasonable doubt? It just seems like, all right, there's civil litigation going on alongside criminal. Happens all the time.
Certainly, but it provides the context for what the defendants were thinking throughout all of this. It provides context for provides context for...
But just admitting the complaint's not going to provide... I mean, the defendants could have chose. They didn't have to, obviously. They could have chose to testify. They obviously have an absolute right not to.
That's correct. We tried to get that evidence in and discuss the lawsuit, everything that went around it, the advice from their attorneys that it was the attorneys driving the multiple substitutions of judges, because the government during the trial and in the indictment alleges that this delay that the litigation caused was part of the scheme to defraud. And so when they're claiming that the lawsuit itself and the tactics, the legal tactics that they're taking, that their attorneys are taking, are part of the scheme to defraud, and we're not allowed to defend ourselves and talk about the lawsuit, talk about the reasonings behind what they were doing, that it was the attorneys that were making these decisions on substituting judges in the trial court, then they're only getting to put on their part of that chapter. So again, it's not necessarily that admitting that document means they're exonerated. It's not. It means that it prevented us from putting on a full case and giving the jury the full information. And the government's the master of their indictment. They complained during the trial that this would create a mini trial on the contractual documents and on the lawsuit. If that was their complaint, they could have amended the indictment and removed those two sections. And then that would have been a much different story about what we believe we should have been able to put on. If there are no further questions. Thank you, Your Honor.
Ms. Boyle.
Good morning, Your Honors. May it please the Court, Counsel, my name is Catherine Boyle on behalf of the United States. Judge Easterbrook, I'd like to start off by apologizing. I did not notice that the rulings weren't in the defendant's appendix, and had we noticed, the government would have
Well, the
provided
rules
them
do
as
not
well.
require the appellee to include that information. We certainly appreciate it when appellees do.
We generally
We
try
had to spend a lot of time rooting about in the record to find things that the lawyers have to know are there and where they are.
The government generally attempts to provide those documents as a courtesy if we notice they're missing from the defense brief, and we would have done so had we noticed it
It's
here.
hard not to notice when there is absolutely nothing
Yes, Your Honor.
of the district court's explanation attached to a brief.
Yes, Your Honor.
Please proceed.
Your Honor, we are here today because the defendants Gary Matthews and Monty Brannon raise a host of claims in an effort to escape responsibility for their part in a years-long scheme to defraud investors and lenders associated with the Pere Marquette project in Peoria, Illinois. I'd like to look at the sufficiency of the evidence arguments first. Turning first to mail fraud, Mr. Matthews, by adopting the arguments in Mr. Brannon's brief, has waived any claims as to mail fraud. Mr. Brannon's brief entirely throws Mr. Matthews under the bus, essentially, in terms of the fraud scheme. Additionally, the evidence was more than sufficient as to Mr. Brannon himself.
On that front, Ms. Boyle, I'm speaking to Brannon purchasing an interest in GEM.
Yes.
And a question about that. What evidence is there that Brannon knew that the periodic updates were sent to investors? Was that part of the GEM operating agreement, or it's obviously a very complex record? Do you have any information on that?
Yes, so Mr. Brannon first joined GEM in July 2011, and once he joined, he shortly thereafter became a co-manager. In his role as co-manager, he would go over these profit and loss statements at monthly meetings, which Mr. Matthews attended also. So he's aware that these are coming in, he knows what they say. And then we also believe through his role as a co-manager, although we don't have anybody directly saying Mr. Brannon saw these mailed out, I think the jury could easily infer that he was aware that this was happening. Mr. Brannon was at the GEM office 3 to 5 days a week. The office was moved to the Pere Marquette Hotel. He was very closely involved in everything that was happening and going over these particular statements as well, Your Honor.
So the inferences would be that the jury could conclude would be from his role with GEM, how often he was in the meetings. Was there any evidence? It was an 11-day trial, obviously a long record. Is there any evidence in there about Brannon speaking to the periodic updates sent to investors?
Well, he attended the monthly meetings with FHD where they talked about them, and we believe throughout the trial, and I can go back, Your Honor, and file supplemental if it's helpful. We believe that there was evidence that Mr. Brannon knew that mailings were going out to the investors on a regular basis.
Is it, I had a similar question. Is that, Brannon invested in July of 2011, as you just said. Is there any evidence that he himself was a recipient of the mailings as an investor before he became more actively involved?
I don't know.
Because he takes on an equity position in GEM.
That didn't come out during the trial, Your Honor, but I also want to say here as well, there's no evidence that presented at trial that Mr. Brannon also got these updates, although I can check on that as well. Something I think that goes also to Judge Brennan's question and may be helpful in yours as well is because Mr. Brannon here under the case law was part of the scheme to defraud, he had the intent to defraud, these mailings were reasonably foreseeable as updates to investors. You also don't need to as closely prove that he knew that a specific mailing went out and what it contained. And that's clear under cases such as Dooley, Turner, McQueen. All these cases show that if it's a reasonably foreseeable mailing in the course of the scheme, that it can be attributable to Mr. Brannon as well. He doesn't have to directly do it. He doesn't have to directly be involved.
Do you know when he invested, did he invest pursuant to a subscription agreement that had terms and conditions requiring periodic mailings?
I don't believe he invested pursuant to a subscription agreement. The subscription agreements were for the original investors who basically were told that their funds would go into escrow, and depending on when you signed on, you'd get 2% or 4% in terms of ownership of GEM. And Mr. Brannon came in and essentially just did a split with Mr. Matthews on the remaining 10%. So this is a different agreement.
If the side letter agreement didn't exist, were the defendants allowed to take management fees?
Absolutely not, and I think that's one of the things that was really glossed over when defense counsel was speaking up here earlier. There's a 2012 contract with Endure that says they are not allowed to take fees once construction is over unless certain requirements are met, and none of these requirements were ever met. There was a reserve account that was supposed to be at a certain amount. The hotel had to be a certain amount profitable. Various requirements that weren't met. The defendants were not allowed to take fees regardless. If anything, the side letter amendment is something of a clarification. And really, I think it was just the city of Peoria looking for some security and transparency as to this $7 million loan, which was their employees' pension fund. This was not an effort to touch on some of the arguments in defendant's brief of the city of Peoria to somehow force a contract under duress. This is really the city looking to protect its employees. There's two parties to a contract. There's going to be a modification to the contract. It's evident that initially Mr. Matthews wanted EM Properties to manage the hotel despite not having direct experience in that kind of thing. He then gets FHG in, and as we all know, Joe Lomonico is basically Mr. Matthews' guy, so he's going to have a substantial amount of control. And I think the city of Peoria was somewhat receptive to the idea that perhaps the hotels could be more profitable. I'm sure they were concerned about the profit levels so far. If Marriott were removed and they had sort of a more Illinois-based company that might know the market a little bit better, in their opinion. But they were also worried because this is something that's giving Mr. Matthews and Mr. Brannon increased control. Under Marriott, there was no... the defendants couldn't see the bank accounts for the hotel's operating accounts. That changes with FHD. So really, the side letter amendment was the city being cautious, and it turns out the city correctly forecast some potential fraud and problems in this case. So it's a long answer to your question of did anything else prohibit it.
There was nothing that prohibited the defendants from calling witnesses from the city that had full awareness of the side letter agreement and its terms and conditions, right?
Now that I'm aware of, Your Honor, I know
they may not have done that, but they could have. They could have subpoenaed all kinds of witnesses that probably had awareness of what was going on with that agreement.
Absolutely, Your Honor. Turning to counts 3 through 5 for the mail fraud, we've talked a little bit about the scheme to defraud, which of course began with Mr. Matthews. He started soliciting investors before the deal was even inked with the city in 2008, and immediately there's a lot of irregularities here. He goes in, he solicits investors, the funds don't go all to the escrow accounts that they're supposed to. He's only supposed to take $500 a month. He takes $1 million fee that he wasn't supposed to take. And then again in 2015, Mr. Brannon's involvement becomes clear. Mr. Brannon has the loud argument with Mr. Matthews in the GEM offices, which is witnessed by Carly Johnson. He goes behind closed doors, and then all of a sudden he comes out, and what does Mr. Brannon get but a $7,500 check from the PMH LLC account. And then these checks keep coming.
And then he becomes a signatory.
He becomes a co-signatory shortly after that. He submits the third certificate of compliance, which clearly makes false statements about what's going on with management fees. So this is when Mr. Brannon becomes really involved, and you can tell Mr. Brannon is an enthusiastic participant in the scheme. It really was actually a turning point in the case. In March 2015, Mr. Brannon could have gone in there and said, "You're taking money. This is terrible. I have to tell the investors. I have to tell law enforcement." And of course, none of that happened. All that happens is checks start getting issued to Mr. Brannon as well.
At some point, the compliance certificates seem to end. Is it the lender's responsibility to go back and say, "Hey, we're not getting compliance certificates like we used to," or whose responsibility is that?
Well, I think it's Mr. Matthews and Mr. Brannon's responsibility to send in the certificates of compliance. They said they would. It's pursuant to the terms of the side letter agreement.
And they did for a while.
They did for a little bit, but not for very long. The fact that should the lenders have followed up, it probably would have been a good idea, but I don't think it invalidates the requirement for Mr. Matthews and Mr. Brannon to do it. And frankly, given what Mr. Matthews and Mr. Brannon were doing, had the lenders followed up, I think they just would have continued to get false certificates of compliance. I don't know that they would have gotten any more helpful information as to the criminal activity going on. So yes, and there's also evidence of Mr. Brannon's involvement. Multiple witnesses testified that Mr. Brannon was very aware, it seemed, when these checks were coming over from FHD to the PMH LLC account. You know, he would always show up for what they called rent check day, and he was there to get his cut after he discovered Mr. Matthews' criminal conduct. So for all these reasons, we think Mr. Brannon is clearly implicated in mail fraud on counts 1 and 2 with regard to the investor mailings, and then again on counts 3 through 5 with the checks that were sent from FHG to the Pear Marquette Hotel LLC account. When we look at the money laundering counts, starting first with counts 7 through 15, the defendants knowingly conducted financial transactions. This seems fairly clear. Both defendants are co-signatories on these accounts. On the PMH account, so any check going from PMH LLC to either EM Properties or to Brannon & Co. is going to be signed by both defendants. They're both helping effect these financial transactions. Defendants don't challenge that some of the money involved in the financial transaction was the proceeds of mail or wire fraud. The evidence presented at trial was more than sufficient to show that they knew the property involved in the financial transactions represented the proceeds of unlawful activity. This is particularly interesting. You have the defendants directing, there's sort of a double deception here. On the first hand, they're directing FHG to classify these payments as rent, but following that, they're instructing Carly Johnson to write in the memo line things like construction management, project fees, and this is again just to make this all look a little bit more legitimate, you know, so it doesn't look quite so much of a payout. And then the fourth element, the defendants knew that the financial transaction was designed in whole or in part to conceal or disguise the proceeds of mail or wire fraud, and that's clear as well. In cases like Jarrett, the court has explained that actions like structuring transactions to avoid attention, depositing illegal proceeds in a bank account of a legitimate business can show the intent to conceal the illegal nature of the funds. Again, they strove initially to hide the source of the ill-gotten gains by having them classified as rent. Then they have the checks issued and try to make them look like they go to legitimate business accounts. And a rational jury would be able to look at this situation and conclude concealment occurred on these facts. I think it's also particularly interesting in this instance that count 7 was a situation where there was a check written from Brannon & Co. to Brannon himself, and in terms of the care the jury was taking with this case, there was actually a split verdict on count 7, which I think really shows that they were parsing the facts here. They were looking at it, and you know, it's certainly possible Mr. Matthews had known about that check, but the jury looked at it and thought, no, that's not quite enough for us. So I think that shows that they were being very careful as they evaluated all of these counts. Mr. Matthews has again waived money laundering sufficiency claims as to counts 16 through 18. Mr. Brannon's brief, just like with the earlier mail fraud counts, fully blames Mr. Matthews for these transactions and says that these were all his machinations, that Mr. Brannon was sort of an unwitting bystander to this criminal fraud. Of course, that's not true either. As far as the elements, the parties stipulated that the transactions occurred in monetary transactions, but sufficient evidence supported that the defendants engaged or attempted to engage in them. As we talked about earlier, they're both required to sign off on transactions that go from the PMH LLC account to the EM Properties account. Additionally, and importantly here, this was charged in an aiding and abetting manner. So because a defendant may be found to aid and abet a section 1957 violation when he adds he may be found to aid and abet it when he adds a signature, when their two signatures are required to negotiate. And Mr. Brannon also cannot claim responsibility because he did not have control over the transactions. He sort of evades the fact that the relevant transaction here is from the Pear Marquette Hotel to EM Properties. Mr. Brannon is alleging he didn't have control over the FHG to the Pear Marquette Hotel account, sort of the landlord account that Matthews and Brannon control. But that is, first of all, not what we need to look at here. That's not the specific transaction we're looking at for this actual money laundering. But second of all, as we discussed earlier, we think Mr. Brannon had plenty of control over everything that was going on here. He was in this office up to 5 days a week and was heavily involved in the fraud and in the day-to-day business operations.
Thank you for the flow charts in your brief. They were helpful.
Thank you, Your Honor. I hope so. If Your Honors have no further questions, we'll rest on the arguments in our brief and ask that the court affirm.
Thank you, counsel. Anything
you, Your
further,
Honor.
Mr. Kelleher?
Briefly, Your Honor, I just wanted to reiterate the nominal role that Mr. Brannon played, and especially the fact that GEM and EM properties, along with this other complex web of corporate entities, all predated Mr. Brannon's involvement. He had no participation with the creation of those entities, and again, it shows that Mr. Brannon came in essentially at an inopportune time, invested in a project that he thought would be profitable. He was misled just like everyone else. So I would just ask the court to consider that context. And then finally, as far as the appendix goes, there was no intent by myself or my co-counsel to mislead. I dropped the ball, and I've been doing this for over 20 years, and this is the first time that's ever happened, so I'm profusely apologize to the court. If there are no further questions, I have nothing further.
The case is taken under advisement. Thank you. Our next case for argument is Reed against Wexford Health Sources. Mr.
Thank you. May it
Ribbage.
please the court. Plaintiff tried this case under a Monell theory of liability, claiming a widespread practice by Wexford of refusing to authorize surgical repair of abdominal hernias until the hernia, and unless the hernia was strangulated or incarcerated. This required plaintiff to prove the existence of this widespread practice, corporate knowledge, deliberate indifference to the risk posed by this practice, and that the practice was a moving force behind the harm the plaintiff claimed that he suffered. Plaintiff failed at trial to introduce evidence sufficient to support a finding on any of these three essential elements. The Supreme Court and this court have repeatedly cautioned allowing Monell claims to collapse into respondeat superior, and that's exactly what happened here. Wexford is entitled to judgment as a matter of law under Federal Rule of Civil Procedure 50, and additionally, the district court committed prejudicial errors at trial that denied Wexford a fair trial, entitling it to a new trial under Federal Rule of Civil Procedure 59.
Can I confirm on that point, though, Mr. Rupich, or that you are, in the first instance, you're asking us to reverse and remand with instructions to enter judgment in favor of the defendant, Wexford?
That is correct, Your Honor.
The new trial business is all in the alternative.
The new trial is in the alternative. Our argument, first, foremost, and primary, is that the evidence was insufficient as a matter of law, such that the case should be, the judgment should enter on remand for Wexford, and there would not be a new trial.
And am I right in reading your brief to say, indeed, in your view, the district court committed error in even admitting the proffered expert testimony of Dr. Clay D. Matai? So it never should have even been, it never even should have been before the jury. And then once it was before the jury, you have, as you argue, a verdict supported by insufficient evidence.
Yes, Your Honor. First off, the evidence should not have been admitted. It wasn't properly disclosed. It was conclusory and lacked foundation for the reasons we said. But that goes to the new trial. If Your Honors look at that testimony, it didn't provide any evidence sufficient to support the existence of this widespread practice. It was a bottom line conclusion from a gastroenterologist that a widespread practice existed. We did not hear testimony from any other persons in custody to whom this applied. We saw no medical records of other persons in custody, and Dr. DeMatti did not testify to a review of medical records of other individuals in custody in similar circumstances, such that a jury could even infer the existence of what needs to be essentially Wexford's standard operating procedure. This is how they act in this situation. With a reducible hernia, they wait until it strangulates or incarcerates.
And here there was no strangulation or incarceration, correct?
That is correct, and that goes to our moving force causation argument. The theory is untethered from Mr. Reed's personal experience.
That actually raises, in my mind anyway, the question whether Reed has standing to sue. If he wasn't injured by the supposed policy, why is this within the scope of Article 3?
Well, he's claiming an injury, but he's attributing it to...
He was, in fact, referred to a surgeon before the hernia was strangulated or incarcerated. I understand that's undisputed, right?
Right.
So I will devote more time, doubtless, with Mr. Palura, but if the policy didn't prevent a surgical referral for him, how was he injured by the policy, even if that was the policy?
We treat that as a failure. We treat it as a failure of the evidence, a failure of proof, a failure of his theory.
It's also a failure to allege injury. We'll talk about this with Mr. Reed's lawyer.
Yes, Your Honor.
Mr. Rupert, how do you think it got to this? I mean, what stage did the train get off the track, such that we've got a theory that differs from the evidence? At what point did this occur? Is it just a cumulative inertia that ends up resulting in a jury verdict on this evidence? Or?
Yes. So it was, I believe it was pleaded. It was in the final pretrial. It was briefed at summary judgment. Summary judgment, we moved. It was denied, and proceeded to trial. And our argument, one of our arguments, was that you can't link them. That they don't line up. It's a square peg. It's a round hole. But to answer your question, it wasn't a last-minute thing that happened at trial. This has been the plaintiff's theory.
Yeah, I thought what you might say in response to Judge Brennan was that set aside the comment or the question Judge Easterbrook has about Article 3 subject matter jurisdiction at the outset, but it seems to me that there's a very substantial question here about whether the district court committed error in the pretrial phase in ruling that Dr. DeMattei's opinion is relevant, reliable, and going to be admissible at trial.
Well, we agree. We filed a Daubert motion.
Yeah, and then that was denied, and then you filed a series of in limine motions. As I understand the record, where you were saying, Judge, there's a real problem with this expert evidence, and all that was denied, and then it got to trial, and then you have the verdict that came back, and now we have an appeal.
I would say we were persistent in making our view heard, including the objections at trial to the testimony, referencing orders in limine. The district court saw things differently, but we believe that was prejudicial error, because that opinion, essentially, we were not able to explore it during discovery. These 6 to 10 other individuals that apparently supported this theory, we would have, if that had been properly disclosed and evidence had been disclosed in discovery of their situations, that would have been how this should have gone. If I see I'm saying something that's
it's confusing me a little bit, because sure. I thought, well, you did depose Dr. DeMattei.
Yes.
And I think I have it in front of me somewhere here. In that you did explore it. He just didn't have an answer for you.
We explored it, but the way this typically would go is the comparators would, we would get the names, we'd get a third-party HIPAA order, we'd get the records, the expert could opine on the records, the expert should not be saying a policy or practice exists, but he can explore the records. We can cross if the
Yeah, all
comparative-
you're saying, I think, is that the reason you couldn't do what you wanted to do in the deposition is because the 26A2B disclosure was deficient.
That's absolutely correct.
Yeah, I got it. I understand what you're saying.
All right. Similarly, the deliberate indifference prong of the Monell claim, plaintiff was unable to point to anything in their response brief that would support that Wexford knew of and condoned this nebulous wait till it strangulates policy. Typically, that evidence would be from repeated past conduct from which the corporate defendant can infer the existence of the policy. And then, as the Dean case says, similar constitutional violations from the policy or the practice. And there's just no evidence in this record linking Mr. Reed's experience, his purported delay, back to Wexford as an entity. On the moving force causation, I won't belabor that as we've already talked about it, but there is simply no basis linking this phantom practice to Mr. Reed, since his hernia was not incarcerated or strangulated. In total, Mr. Reed, the plaintiff, failed to provide evidence to support a finding on any of these three essential elements. We additionally moved and renew our argument that punitive damages were inappropriate in this case. They, according to Smith v. Wade, a long line of cases, they must be supported by evidence of an evil motive or intent, callous, reckless indifference to federally protected rights, and a $500,000 punitive award in this case for a corporate defendant that had no involvement in the care until it was asked to approve a consult, and did it, and approved every follow-up, approved second opinions, approved outside shots, approved a second surgery, and there's just no basis to punish this defendant to the tune at all, or much less to the tune of $500,000. In our motion for a new trial, there were several issues we raised concerning the disclosure of Dr. DiMatti, his opinion principally on this widespread practice that he testified in conclusory form was not sufficiently developed in discovery, and the opinion he gave...
Did you have a statistician look at Wexford's records?
I did not.
I mean, I can think of two ways to show that the policy in operation differs from the policy on paper. One is to draw a random sample of all prisoners with hernias and find out when, if at all, they're referred for surgery. The other is to draw a random sample of those who were referred for surgery and see what the status of the hernia was at the time. A statistician could tell you whether there's a significant departure from the stated policy. You didn't do it. I gather that Mr. Reed didn't do it either.
It was not done. I would agree.
Now, of course, the plaintiff is the one with the burden of persuasion or the risk of non-persuasion.
Yes, that we did not affirmatively seek that evidence. It was not put forward in the first instance.
It's the kind of evidence you would expect Wexford to have on hand just to see how well it's doing. How does Wexford know if its policy is working right if it doesn't gather that kind of evidence?
I cannot speak to all data that it has, whether it could look at all hernia referrals that are sent out and then determine, if their theory were true, picking up the thread, we would only see referrals for incarcerated and strangulated hernias, right? That would be.
That's right. If you look at the referrals, they would all be for incarcerated or strangulated hernias. Wexford should be able to tell whether that's true. That should be in Wexford's own records. And if it sees that, it should know its policy is being misapplied, as you've told us the meaning of policy. And presumably, whether you're a healthcare services company or an airframe manufacturer, you gather that kind of data and see whether your policy is working. But I gather Wexford doesn't gather the data?
It's not in the record in this case. I can
so
answer your question if you want me to answer it.
No, it's limited to the record.
I believe that the data exists. I'll leave it at that. And, but we know there's one individual who would not fall into that category of just referrals for incarcerated and strangulated hernias, and that's Mr. Reed. I did briefly want to touch on the question of whether an expert should be giving a bottom line conclusion on the existence of a policy or practice. This is something I've run into a lot, and it's something I object to vociferously, and I did in this case. I don't believe it's appropriate. I don't think a medical expert should be drawing the jury's conclusion. I believe it's a jury question whether a widespread practice exists at all, and in the event this case were to be remanded for a new trial, that would be an issue on remand.
Thank you, Mr. Rubich. Mr. Pliora.
May it please the court, counsel. My name is Tom Plura. A lot of talk about Dr. Damati.
Before we do that, we need to talk about federal jurisdiction.
Okay.
How was Mr. Reed injured by the supposed policy of not referring to a surgical specialist until the hernia was incarcerated or strangulated?
Well, my client,
Please face the court.
Yeah, my client got castrated while he was waiting to be sent for surgery. He was castrated, his right testicle removed.
Could you
He was in
explain
pain
how he
for-
was injured by the supposed policy?
Okay, so they have a facially unconstitutional custom and practice of not referring.
Counsel,
Yeah,
this very policy has already been sustained by this court against a constitutional challenge. Your argument is that the policy is not carried out as written. I'm trying to figure out how your client was injured by the policy.
I'm not, you're talking about this court ruling on the written policy. We are not talking about any written policy. We are talking about their custom and practice, which does not refer patients like Mr. Reed for surgery unless he incarcerates or he strangulates. And in this case, he filed a lawsuit, and that's what spurred things. But he doesn't have to.
I wish you would address my question.
Okay.
Could you explain how Mr. Reed was injured by the supposed policy, by the policy that you contend exists,
Sure.
when he was referred to a surgeon before his hernia was incarcerated
Okay.
or strangulated?
There is no requirement under the United States Constitution for a patient to, like,
Counsel, please listen to my question.
Sure.
I'm not asking you to address constitutional law. I am asking you to explain to me as a factual matter how your client was injured by the asserted policy.
He was injured because of the delay in treatment, which led to pain, disability. He was being forced to reach into his pants and hold his hernia up from his testicles. There was testimony where his testicles and the hernia had dropped down halfway down to his leg. So that's an injury. That injury forcing that patient to wait, and he wasn't given a single Tylenol in a year, not one Tylenol.
But the policy concerned the strangulation and the incarceration.
Well, yeah.
Let me finish. If that hadn't happened yet, how could they be responsible for violating the policy? That's the question.
Well, if they don't refer a patient out until their custom and practice is don't send them until it incarcerates or strangulates, they ignore the pain, they ignore the disability, they ignore the fact that he lost his testicle because of the delays. And Dr. Damati testified to that.
We can't ignore all of the law leading up to that, though, which provides that for it to be a deliberate indifference constitutional violation, it's necessary that there be that custom and practice. You've advocated that there was a policy, but then the facts in this case don't show a violation of that policy. This isn't a medical negligence case. This is a deliberate indifference constitutional violation case.
They do show that because he was never referred out, he is sending out letters to the warden. He's doing the grievances saying, I need to be sent out for my surgery. I need pain medicine. He filed 4 different grievances starting in November. He filed a grievance, an emergency grievance on Christmas Day.
Mr. Plura, can I try an iteration of the same question? Here's what I understand that you're saying. Correct me if I'm wrong. What you're saying is, I agree with the court that my client, Mr. Reed, he did not have an incarcerated or strangulated.
I agree.
He did not.
I agree.
But what he did have was a hernia condition that was resulting in terrible pain and discomfort for a long period of time.
Yes.
And what you're saying, I think, is that, no, I'm not arguing that it violates the policy written down on that piece of paper. That's not my argument. My argument is that it violates a different policy, a policy that operated in practice.
That's correct.
Whereby the defendant, with people like Mr. Reed, was delaying treatment.
Intentionally.
Okay, fine. So
that's exactly, and
that's the theory.
We have tried to separate out, and we did. They filed a motion in limine to bar Dr. Damati from testifying about the written policy, Wexford's written policy. This has nothing to do with the written policy.
Okay, all right. I think we got it framed, okay?
Yep.
Okay, now, here's what I'm concerned about.
Sure.
I think I understand what the claim was. What is the pattern and practice evidence that you put before the jury? What do you see it as?
Twice one is 2. We submitted the evidence of Mr. Reed going in repeatedly, asking to be referred out, asking for pain medicine, and individually he had repeated multiple episodes.
Okay, right, but his own experience can't prove the pattern and practice. It can prove a miserable experience.
No, it can. Under Glisson, it can. Under Glisson, it can constitute. An individual doesn't have to come in and prove, okay, I got 20 other inmates. Repeated instances against one individual, and we have that from
keep
August.
Keep going. What else do you have?
Okay, so he's told Wexford doesn't do surgeries electively on hernias. That came directly from the agent or the employed physician, Dr. Larson. Additionally, we had the testimony. Now, they filed a motion in limine saying, you can't bring in, we don't want any other information in about other inmates, because All of those cases had been disclosed, and the judge said, what about it, Mr. Pleur? We don't have any intention to go in and have 5 trials within a trial. What Damati is going to testify to is, and what they had the disclosures of, was all of the cases. We had the same expert, we had the same...
Counsel, when you say all of the cases, what is in the sample of all?
Well, we had Bryant hernia case, we had the Noser case, we had the Davis case.
The cases you referred to, Dr. Damati, right?
Yes.
The cases you referred.
Yes.
Did Dr. Damati draw a sample of all of the cases involving hernias in the Illinois prison?
12 to 15,000? No. Dr. Damati did not do that inside the prison system.
Did he look at a sample of the cases that were referred for hernia surgery?
No, he did not.
Those are the 2 ways one might think of showing what Wexford's policy is. Otherwise, what you have is anecdotes.
Well, I disagree with the court on that. I don't believe that would be the only way to do that, nor do I think it would be realistic to think that a pro se inmate could figure that out.
I don't believe that Dr. Damati is a pro se inmate.
No, Dr.
Presumably he knows what he's doing.
He does. He's done over 1,000 surgeries, hernia surgeries.
An expert in hernia surgeries is not the person you needed. You needed a statistician.
Yeah, and I respectfully disagree that the case law would require an inmate who, it's very rare that we would even have an
inmate is not a statistician. You needed expert testimony to show what the policy was, rather than just what your clients wanted to say to Dr. Damati. Right? There's a big difference between your clients and Wexford's policy. You may not think there's a difference, but as a statistical matter, there is. And the right testimony comes from somebody who does a statistical analysis.
Yeah. I don't think the Constitution requires that. I don't think our U.S. Supreme Court requires that to prove a deliberate indifference in a prison setting for health care, that the inmate would be required to get a statistician. I don't believe there's any case law to support that. I think it's very unusual that an inmate would get to this status to where he's actually denied care for a year and then lose his testicle because of that. And I don't think the fact that he didn't go out, or I didn't go out and retain or hire a statistician, would bar him from recovery. Because this court has substantiated just simply having pain is enough to prevail and get to the jury on a deliberate indifference case.
You mentioned Glisson, so I assume you have some familiarity with the Supreme Court's Monell case law and our Monell case law. It is not as tepid as you're portraying. There are a series of hurdles that both parties have to go through. And Mr. Rupich described those, including what are the evidence of comparators, the ability to be able to set up a pattern of practice. Otherwise, Big Muddy is in Jefferson County, Illinois. That would be where the case would be versus some type of a federal claim.
Sure. Your Honor, in our brief, we cite that one comparator is enough. We cite the case law that says there isn't any magical number that you would have to go out and do a statistical analysis. One case, one person is enough, and we've cited those in our brief. If there are repeated instances of denying him his treatment, and that happened over a year period, and it happened in the face of 4 grievances and repeated requests for care and treatment. And to say that Wexford didn't know about it, Wexford actually, they're the prison contractor, they approved a referral out. They didn't approve surgery. They approved a referral April 19th, 2021, and he doesn't even get his surgery until September, and he's issued a ticket for complaining about the pain. And so to say, well, Wexford didn't know about it, it's in there. They knew about the referral. Now they said, well, it wasn't in April, it was actually in June. The only reason he got to a surgery was because he filed a pro se lawsuit against Wexford. And then I was asked to get involved. But for a pro se inmate filing a lawsuit, he would still not have a surgery, and he would be without his right testicle, like he is today. You know, I want to emphasize that an inmate is not required to play Russian roulette involuntarily, and that's what Wexford is doing. It's an involuntary game of Russian roulette where they force a patient to suffer from a hernia, go through pain, go through disability. He can't walk. He's having to hold his scrotum up and deny him pain medicine. They didn't mention that, not one pill. And even the time when they know about it in April, they try to say, well, that was a typo, it was June. The reason they want to do that is they want to shorten the time frame between the time that they sent him for a consult until the time that he gets his surgery. Dr. Damati testified that the horse is out of the barn.
Yeah, Mr. Plor, I want to go back to a Monell-related question. I totally
Sure.
understand your theory of him receiving negligent medical care. That's very clear to me. You've done fine on that. Okay. My question is, how is Dr. Damati's expert disclosure, how does that comply with Rule 26, the disclosure required under Rule 26?
Fully complies. It's
How?
a seven-page detailed report, 7 pages, and we supplemented that December 1st with another 15 pages. So there were 22 pages of written disclosure.
Yeah, it's not a matter of page counting. Okay?
Yeah.
I've read them all.
Yeah.
Okay. What I'm not focused on his discussion of what your client suffered.
Yeah.
I'm not, okay? It's the pattern and practice evidence or the lack thereof. Where's that disclosed?
Well, it's in there. It's in
I got it right here. Where?
The December 1st supplement goes into that in detail, where they have a pattern or practice of ignoring hernias. That's in the supplemental disclosure that was December 1st, 2020. I think it was 2021.
Yeah, it's like a 7-page document or so.
No, the 7-page document was the initial disclosure. Then there was a 15-page document, Your Honor.
All right.
Thank you.
Yep.
Thank you, counsel. The case is taken under advisement. Our third case for argument today is United States against Stewart. Mr. Roy.
Thank you, Judge. Good morning. May it please the court, opposing counsel. My name is Michael Roy on behalf of appellant Daniel Stewart. This court should vacate Mr. Stewart's sentence for 3 reasons. I'll just jump right into it unless the court has a specific issue they want me to address first. So starting with the career offender enhancement, I know there's a lot in the briefs about our disagreement about the standard of review. I think the briefs cover that pretty thoroughly, so I think I just want to say our position is plain error, whether it's forfeit or not, doesn't really matter. We're already facing Stinson. We recognize that's a pretty steep standard. I think if we meet Stinson, we're necessarily meeting plain error, so I just want to jump straight to the merits. Like I said, I understand Stinson is a steep standard to meet, but I think that reading the text itself, there's only one conclusion to draw, which is that subsections B and C were meant to be applied in the alternative. I think the textual source for our argument is primarily the phrase at the beginning of subsection B that says except as provided in subsection C. That's often used to flag that different provisions work the alternative. We think that that position is further reinforced by the repeated use of the phrase otherwise applicable. The first time otherwise applicable is used in subsection B, I think there's no dispute. It's referring to a non-career offender enhanced range.
Has any court of appeals adopted your reading of section 4.1, 4B, 1.1B?
Thank you, Judge.
It's a
I
tongue
understand.
twister.
Yeah, I'm trying to avoid the tongue twisters here. No court, as far as we could find, has even addressed this argument.
Okay.
Which, in terms of whether it being plain error or not, we think that kind of helps us in that we're not asking for a circuit split. We're not trying to differentiate any other authority. The argument is the same whether it's preserved or not. We're, as far as I can tell, the first time this is being argued. That being said, I do still think the text supports our position. As well as the actual phrases in it, the fact that the charts at C3 in subsection B, that they're designed to meet the same outcomes, I think is helping to reinforce that when the Sentencing Commission created subsection C, they were just trying to create a simple way to come to the same conclusion. Like, we know 924C, it goes from 5 to life, but it's often treated as sort of a strange, different provision. I mean, this court sees many cases with 924C convictions, and it's almost rote for many sentencing judges to say +5 for the 924C. So the Sentencing Commission wanted to make clear, no, treat this as if it is a maximum life, which it is, and then this is the ranges you would get applying the regular career offender rules. The government's objections rely mainly on policy concerns. Obviously, policy can't overcome textual analysis. I'm happy to address any of the government's policy arguments, but unless this court has questions about that, we would rest on our textual analysis and I would move on to the other claims. In terms of our second claim, based off of the Supreme Court's decision in Pepper, the government, I think, misconstrues our claim. We're not arguing that district courts are required to reward rehabilitation. We're not arguing that there's any sort of categorical bar against considering any information at sentencing, or at least nothing that was at issue in this case. We're not arguing that the court somehow created a disparity or that there's like a forbidden factor analysis. It's very simple. We think the court just did not understand that it had discretion to consider the rehabilitation as much as it wanted. This is, I think, similar to Castaneda, where there was kind of a muddled record. The district court was not entirely clear whether it understood that it had discretion or the extent of its discretion to go below a mandatory minimum when the safety valve applied.
But what do you do about I think you argue about this in your brief, there's a passage in the sentencing transcript, right, Mr. Roy, where the district court judge says, I just don't think it would be fair to award a drastic variance because that would all but overlook the underlying offense conduct. And, the sentences that attach to offense conduct like this, see all the other people that are doing time on charges like this.
Well, I think
isn't that just an exercise of discretion not to vary more downward or to grant a more reduced sentence?
I think that sentence in isolation, yes, that would be an exercise in discretion. But, transcripts aren't statutes. You have to read them in context, right? And it's the paragraph as a whole that wraps around 51 to 52 of the appendix where this is the section where I'm talking about the 3553A6 factor. The court doesn't cite the statute, but that's clearly the statute the court's talking about unwarranted disparities. It says, okay, I'm marching through the factors. I'm going to address unwarranted disparities. What I think unwarranted disparities means is that I have to limit how much I reward you for your post-sentencing rehabilitation. And that's just wrong. Post-sentencing rehabilitation or, aggravating facts post-sentencing for that matter too, they simply do not have anything to do with A6. It's nothing that's not a disparity thing. The court misunderstood that it could have varied as much as it wanted to. I mean, it didn't have to, of course, but it could have as much as it wanted to, and A6 had nothing to say about that. That's the holding of Pepper. Lastly, our third claim about the money laundering counts that the court doubled on resentencing. I want to distinguish that there's really two issues here. The first is whether there was an error at all, and the second being whether concurrent sentence doctrine applies. We knew from the outset concurrent sentencing was going to be an issue with this claim, but assuming we went on the merits, I think we have laid out our arguments for why this court should not exercise this discretion to use the concurrent sentencing doctrine. First of all, concurrent sentencing doctrine is discretionary. It's not something this court has to do. It's not a jurisdictional issue. As we point out, the Ninth Circuit has essentially abolished the doctrine altogether. And we're sort of in a weird place right now where there is actually headwinds towards clemency for drug offenders. There was a lot of political will building up to the current administration, and now there's a specific pardon czar appointed. Her role is not entirely clear yet, but it seems to be that there is going to be some sort of program based specifically on drug offenders. Money laundering is a different kind of fish than drug offenders. This doesn't fall into the same sort of policy arguments about mandatory minimums for nonviolent drug offenders like Mr. Stewart. Sorry, Judge Brennan, it looked like you had a question.
I'm good, thank you.
As for the merits itself, the government is saying he's not entitled to an explanation. I would disagree. I think an explanation is almost exactly the description of what due process means. Of course, the court doesn't have to march through checklist fashion, doesn't always have to go through each individual count. But I think Wiltshire is a good analogy here. In most cases, the mine run cases, a district judge does not have to give a separate explanation for the length of supervised release versus the length of prison, because it's implied, right? Anyone reviewing the transcript understands. Wiltshire was a weird example where the court's explanation for the prison sentence could not have applied to the supervising release because they were focused on punishment, which isn't something, I mean, there's technical reasons, but it was, you couldn't look at the transcript and see the implied reasoning. We have the same thing here. There was no new aggravating sentence, or no new aggravating information at resentencing, only mitigating information at sentencing. Nothing else got raised. It's hard to speculate why the court raised the money laundering counts, but it seems most likely it was just a mistake by the court. And I'll reserve the rest of my time for rebuttal unless there's specific questions.
Thank you. Certainly, Mr. Roy. Mr. Clark.
Thank you, Mr. Roy. Colin Clark on behalf of the United States. I'd like to start with something that applies in plain error review, but not in Stinson review, is the issue of novelty. Novelty, like an issue that is unsettled, is not normally reviewable in plain error. In both the reply brief and in the page dissent, the case of United States versus Ruth gets mentioned as an example. And so I tried to figure out if the issue was even argued there. I pulled up the United States brief from 2020, and this sentence is included, and it quotes a case by this court in United States versus Ramirez. The line reads, "This court rarely finds plain error on a matter of first impression." And I'm happy to provide a 28J letter on Ramirez because it was not cited in the briefs. But the point is that this court has long held that when the law is unsettled, we don't normally reach new issues unless the issue is so obvious that plain error review is warranted. And so my opponent has come up here and said, not only is plain error review in Stinson the same, this is the first time anywhere anyone has ever heard of this claim. That makes this case an excellent vehicle to deny that claim as a matter of plain error review because the issue is novel.
Moving beyond the standard review, what's your best textual argument that the relevant application note doesn't conflict with the guidelines?
The application note contains a definition. How can a definition conflict with a guideline? Unless, say, the sentencing commission defined a term, say, we're going to define a horse as a chicken. That perhaps could be a definitional conflict. But what they said is that an otherwise applicable guideline range, which is a phrase that's only used in this one part of the guideline, means that you take the mandatory minimum from the 924C count, and then you apply the table in subsection B, and you add the minimums to the numbers in the table. And it's just that simple. There's no conflict at all. I honestly fail to see my opponent's point on this, how there is a conflict. It's simply a definition to a term used in the guideline. That would be my best argument. And so I think it's also helpful to note, although not as an issue plain error, but simply on the merits, that this guideline has been applied without any argument for 25 years almost. And so it would simply be that we've all missed it for decades, and that kind of perhaps suggests that there isn't a problem at all. And also, the Sentencing Commission, the same one that wrote this guideline, and the applicable part has not been amended, also included the commentary, the definitional phrase. If you look at the language that they proposed initially in November of 2001, the United States raised an objection suggesting that the proposed language would raise an anomaly where certain offenders would actually get a sentencing credit by becoming a career offender, and therefore they changed the language and included a definition that was eventually proposed to Congress. That's, I believe, in footnote 3, at least, contains the citations to the public comments and the original proposal. And what I found in further research, because obviously my hypothetical contained an error, I missed the trailing asterisk, and so I agree with my counsel that the two, Boudreaux and Thibodeau, would have the same sentencing guideline in the end. But the point is that for issues of, say, at the time, 924C stacking, there could be an issue where, at least in the Sentencing Commission's initially proposed guideline, that two 924Cs would actually benefit from being a career offender, which would be absurd. And that's why it was changed to its present form. Unless there are more questions, I'm going to move on to the Pepper claim. This is kind of an unusual issue because both sides are claiming that we are for greater discretion for the district court to consider issues. And I kind of fail to see my opponent's point. As Judge Scudder, as you pointed out, the key issue is whether the district court thought it would be fair that this person standing in front of him would get a drastic variance because of post-sentencing rehabilitation when many, many other offenders don't get that. That is an exercise, as you said, in discretion. And although the Pepper Court presented just a completely different issue. It dealt with whether we could eliminate that issue altogether. And you could eliminate post-sentencing rehabilitation as a disparity in two ways. You could either have constant resentencings, where everybody would get resentenced all the time to evaluate how they've been doing in prison, or no one ever gets to talk about post-sentencing rehabilitation. The Pepper Court said, look, this categorical rule makes no sense, and it's not a correct application of 3553A6. And so that's why they used in that line my opponent relies on so frequently, that Congress didn't seek to eliminate the disparity. That has no bearing on whether a district court can seek to reduce the disparity by saying, look, I'm going to consider your post-sentencing conduct, but I'm not going to give you a drastic variance because it's a disparity that I'm seeking to reduce. He didn't eliminate it. If he did eliminate the disparity, he would have said, I'm never going to consider your post-sentencing rehabilitation.
I think what the district court was saying is that there's no question you have exhibited positive rehabilitation, you're doing some good things in prison, I'm going to reward you for that. But I'm not going to reward you by saying you're released this afternoon. There's kind of a limit to it.
Correct.
And the limit is you committed some very, very serious offense conduct and you got a tough record. And that offense conduct lands people in jail oftentimes for the rest of their life. And so all he did was temper the exercise, the kind of limit, the exercise of his discretion.
And I agree with all of that, and I don't understand what was he supposed to have considered, because my opponent's argument is that his sentencing discretion was limited in some way. He did consider, and he chose not to. The argument that
Mr. Roy's doing a very good job for a client in a tough spot. And the argument he's making is, well, hold on, where the district court went wrong was in referencing, the other offenders, meaning the ones that didn't have an opportunity for resentencing. And he's asking us, on Mr. Stewart's part, to say, look, you really can't do that. Focus on the person in front of you. Don't focus on all these other people.
And if that is his argument, then he is saying that considering other offenders not before the court who are in a similar position is a prohibited factor. I fail to see the conceptual difference.
I think that's what he's arguing. So we have to decide whether he's right or not.
His reply expressly disowned that argument. And I
don't know.
But maybe I'm sure he will tell you whether I'm wrong or not. But I think regardless of what his argument is not a prohibited factor. I think the best place to go is Concepcion, where in the footnote they say, look, it is a feature, not a bug, to consider that sentencers will consider disparities differently. In that precise case, there were offenders who would have been able to get the benefit of a non-retroactive career offender guideline where others wouldn't. And the court says, yes, of course, because they're in front of the court, they can consider that, not despite the fact that there is a disparity, and those disparities can be handled differently. What Justice Kavanaugh called the haphazard windfall scenario is very similar to maybe what Justice Stewart would call being struck by lightning in Furman versus Georgia. The fact that some offenders get what in the sentencer's view special treatment for having a rare opportunity for extra punishment or extra leniency is something that is fairly taken into account. And all we're saying is that it's fairly taken into account. The last argument, as to the first issue, I don't see how JET doesn't apply on all fours on this case. I don't really see my opponent's argument on that. And as to whether it would always be the case that reducing a person's sentence might help them in some sort of quest to get a pardon or commutation, but that would eviscerate concurrent sentencing doctrine. The argument he made failed in Dean, United States versus Dean, which is what JET relies on, and he's re-urging it here, and it's just a foreclosed issue. If there are no further questions, thank you for the court's time.
Mm-hmm. Thank you, Mr. Clark. Anything further, Mr. Roy?
I just want to turn back to the A6 issue. I wouldn't quite put our argument as we're saying prohibited factor, courts can never consider other defendants' sentencing. The district court in this case didn't even consider other defendants' sentences, except in like the abstract sense that other defendants exist. Of course, courts can consider other defendants in appropriate contexts. Reyes-Hernandez, the case the government cites as an example when they're comparing fast track. Another example would be, say he got a lower sentence because he got resentenced, was on supervision, immediately screwed up, revocation proceeding. The judge throws the book at him saying, look at this amazing opportunity you got that most people don't to get out early. That would be a totally appropriate consideration for the. The problem here was that the judge misinterpreted a direction from Congress. The judge essentially said, Congress directed me to limit my consideration of the rehabilitation material. And Congress didn't do that. That's the legal error. And it is a unique case in that this is pretty exceptional rehabilitation material. I mean, he had the 13 letters in support. The courtroom was full of supporters. Even when he was in a life sentence, he was doing everything right, which usually there's not as much of a motivation to behave well in prison if you're there for life, but he did it. He was doing charity work, everything. He was a kind of a unique experience. Unless there's further questions.
Thank you, Mr. Roy. The case is taken under advisement. Case number 4 for argument this morning is Epic Systems against Tata Consultancy Services. Ms. Winbrandt.
Good morning, Your Honors, and may it please the Court. My name is Catherine Winbrandt, and I represent Plaintiff, Appellant, Epic Systems Corporation. The District Court erred in holding that post-judgment interest runs on Epic's punitive damages award from the amended judgment in 2022 rather than from the 2017 judgment reflecting the jury's verdict. In prior phases of this litigation, the Court has already made clear that the jury's decision to award punitive damages was factually and legally sound, and the only basis for reducing the original judgment was the $140 million cap on punitive damages under the Constitution. In other words, the factual and legal bases for Epic's entitlement to punitive damages have been left undisturbed since the 2017 judgment was entered. After all, the jury was impaneled only once, meaning that the District Court's amended judgment was effectively reinstating the portion of the jury's initial award that fell within the constitutional limit.
Ms. Winbrandt, the District Court here is in a position of Western District of Wisconsin applying Seventh Circuit law. It's got Devane, it's got Harris, and then there's a lot of out-of-circuit precedent as well. Is there daylight between Devane 2, and Harris, and how would that apply for this case?
We believe that Devane and Harris are fully consistent with our position here. Devane is probably an easier place to start because it helps us draw the line between a judgment that is inappropriate to run post-judgment interest from and an excessive judgment that is appropriate to run post-judgment interest from. So that earlier judgment in Devane 2 was factually and was not factually or legally sound, and the court had further fact-finding work to do. Whereas in that second judgment, it was excessive, but post-judgment interest could run from that judgment because the bases for the judgment were factually and legally sound. Harris is a case that predates the Supreme Court's opinion in Kaiser, but even there, the factual and the legal errors in that opinion, as the court said, they infected the judgment as a whole, and to the extent it was impossible to say, is the quote from Harris. And so what the court had to do was go back and start from scratch. Whereas here, what the district court had to do was determine where an outer boundary of punitive damages would lie. And in doing so, it had to consider the facts and circumstances of the case as the jury found them. And the court understood that it was preserving a component of the jury's initial verdict, as it had to, because the decision did not go back to the jury. And neither party has identified a case where damages were determined by a jury in the first instance, and post-judgment interest ran from a later judgment without needing to send the damages issue back to a jury. And the same result should obtain here.
If you step outside the case law for a second and you think of the case as presenting a question of statutory interpretation, what are the one or two sentences you would urge us to adopt to reflect an accurate construction of the statute?
So I think the starting point here needs to be the Kaiser's meaningfully ascertained standard. But if we're looking at the statutory text, I'd urge this court to look at two tools, and those are the two tools we cite in our brief. One is contemporaneous legal dictionaries that look to the word recovered as being the point at which an individual's factual and legal entitlement to damages is established. And the second is the pre-enactment precedent of the Supreme Court interpreting virtually identical statutory language using the word recovered and making clear that it's immaterial what the label of the disposition was and what the court should look to as what was happening in substance. And any matters that are reflected in the first judgment and incorporated into the new need to be understood as being embodied in the first judgment, and therefore post-judgment interest runs from that first judgment. So as a matter of statutory interpretation, we would look to the dictionaries and the pre-enactment precedent. And we think Kaiser's meaningfully ascertained standard.
What strikes me as odd about this case, counsel, is the district judge distinguished between the $140 million in compensatory damages and the $140 million in punitive damages, even though they're both covered in the 2022 judgment. So if the punitive damages were not recovered in 2017, why would the compensatory damages be recovered in 2017? I could imagine treating them the same, but I'm having trouble with the difference. Have you found any cases that distinguish, for the purpose of the word recovered, between these kinds of things when there's a new judgment?
It's a good question, Your Honor, and I don't believe we found cases that have distinguished the word recovered in that regard, but the way the cases just tend to treat judgments is looking at punitive damages separate from compensatory damages. But if the court were to want to consider those the same, and it's a good point that the post-judgment, that the 2022...
No, I hope you understand my problem. I hope Mr. Conrad does too. If the $140 million in punitive damages was not recovered until 2022, I don't understand why the $140 million in compensatory damages was not recovered until 2022. Right? I'm having trouble seeing how the statutory languages distinguishes between the two.
Right.
I can imagine treating them as both 2017 or both 2022. I'm having trouble with the distinction.
Well, certainly, Your Honor, we believe that to the extent this court were to treat them the same, they would both have to run from the 2017 judgment, and TCS does not disagree that the...
Tata has conceded that the compensatory damages run from October of 2017.
Precisely.
But since the whole award was restated in 2022, I don't understand how that concession is consistent with defending the district court's decision. And I'm trying to figure out, the statute doesn't clearly resolve this one way or the other. Are there cases that tackle this problem? Maybe not.
The cases that we believe are helpful in tackling this problem are the ones that look at punitive damages being vacated as excessive and reduced. Johansson and Exxon and Dunn, and those were cases where there were compensatory damages awards as well. And so to that extent, the court's treatment of punitive damages as a distinct question to determine whether those were meaningfully ascertained as of the earlier judgment, those cases are instructive. But to the extent those cases are not instructive, then it would counsel in favor of automatically running post-judgment interest from the date of the initial award. And then you would just look to the legal dictionary.
It could be. It could automatically start in 2017, but I could certainly imagine a rule that damages are recovered for purposes of 1961A under the judgment that's actually being executed. And the judgment being executed was entered in 2022.
Your Honor, we would submit that is just inconsistent with the whole of the case law that we've cited in our briefs, in addition to the purposes of the statute. And we think the Supreme Court's articulation of the purpose of the statute in Kaiser and this court's articulation of the purpose of the statute and merit are instructive here, where the court looks to whether it's more just for an adjudicated wrongdoer to hold on to interest-free money during the period of time between when the damage is first ascertained and payment of the judgment. And here, it is certainly more just for TCS as the adjudicated wrongdoer to not hold on to interest-free money, which it does not dispute, allowed it to reap hundreds of millions of dollars in benefits during that relevant period.
How much discretion, do you think the district court had to reduce the number on remand?
We don't believe the district court had any discretion to reduce the award
but
below $140
is that view, though,
million.
is that consistent with what we wrote in the prior opinion? Because we say, at most.
We say this court did say at most in the prior opinion, and I do want to be mindful of saving a minute for rebuttal, but to complete the answer to your question, this court clarified in Epic 2 that in Epic 1, this court had determined that $140 million was constitutional, and the constitutional issue was all that was left. So we disagree that the district court had discretion on remand, but nothing about
Hold on,
this
say
question.
that again. You disagree?
We don't think that the district court had discretion to reduce the award below $140 million on remand.
That's in your, all right.
But we don't believe anything in this appeal turns on that, because whatever amount that the district court had imposed on remand from Epic 1 would have been a component of the jury's initial verdict. And I will save the remainder of my time for rebuttal.
You've saved about 10 seconds. Mr. Conrad.
Good morning. May it please the court, Neil Conrad for TCS. The district court's decision should be affirmed because it is correct under the plain language of the statute, consistent with the case law, and in particular the most important
On
cases.
your view of the plain language of the statute, why isn't interest on the compensatory damages deferred till 2022?
Compensatory damages were treated differently in this case because there was an agreed order regarding security during post-judgment proceedings.
That's fine, but the judgment that is going to be executed was entered in 2022. It provides for both compensatory and punitive damages. I can't see any dating difference for purposes of the statutory language, civil case recovered in a district court, between the two amounts. They were initially provided in 1917, and then there was a new judgment in 2022. I can imagine running interest on both of them from 2017 or both of them from 2022. I hope you can see why I'm having trouble starting the running on one of them at one time and the other 5 years later.
Judge Easterbrook, I do understand the point about the statutory language. My point is that the parties agreed, essentially by contract through the agreed order, to treat compensatory damages differently. And in that order, what TCS and EPIC agreed to do was that as soon as a portion of the judgment was affirmed on appeal and there were no further opportunities to seek appellate review, including through a petition for cert to the Supreme Court, TCS agreed to pay that amount. And that's exactly what happened. That's
What was the date of that?
The date of the agreed order.
Of the payment?
I actually don't. I don't know off the top of my head what the date of the agreed payment is.
The year?
It is referenced in. It is referenced in the briefing on the post-judgment interest issue in the district court, and also referenced in the district judge's order. I don't remember the specific year, but it was before. It was before the parties even submitted the briefings on the post-judgment interest with respect to punitive damages issue in the district court. So that was completely off the table when Judge Conley took this issue up and the parties briefed it and disputed how post-judgment interest would be dealt with respect to the punitive damages award. That's essentially why it's been removed from the case.
So what you're saying on that is EPIC tried, to mitigate what it was going to have out of pocket by paying quickly, narrowing the litigation, and the litigation narrowed to focus on when the interest was going to run on the punitives. That just is a very practical matter what happened.
I think you said EPIC, but I think you meant TCS.
Yes,
That's
TCS,
right.
I'm sorry.
Essentially, that's right. The parties agreed to basically limit the issues going forward. They did this ex ante because they knew that there were going to be different kinds of compensatory damages potentially and punitive damages. It's a very practical solution to a problem. It's been removed from the case, and I don't think it affects the question before the court now. It's just out of the case. And the question before the court now is what to do about post-judgment interest with respect to punitive damages.
Is there any legal significance, Mr. Conrad, in your view, to the fact that the prior judgment was vacated?
I do think there is legal significance to that. In particular, the legal significance is the punitive damages portion of that original judgment was vacated, and therefore there is no basis on which to say the amount of punitive damages were
meaningfully
meaningfully
ascertained. So would your position
ascertained.
change if in the prior opinion the final paragraph said reversed and remanded so the judgment can be modified?
I do think that makes it a harder case. I still think we have arguments with respect to the plain language of the statute, and some of the cases that have been cited in the briefing I think would still support us because they would focus on just the reversal. But it's a harder case, I recognize, because there are out-of-circuit cases that we wouldn't be able to as easily distinguish. The fact that the opinion from Epic 1 says at most makes this an easy case for us. The reason why is because there's no way you could say that punitive damages were meaningfully ascertained until the district judge on remand applied the guidance from this court in Epic 1, considered the record again, and set a new judgment. And I want to make two...
Did you really think on remand, though, that the range was going to be, from $1 to up to and including 140 million? Anything in between?
We thought that we had very strong arguments for why, if punitive damages were going to be awarded at all, that they should be much closer to $1 than 140
But the
million.
district court had already entered a judgment for 280 million in punitive damages.
That's right, but he had done so essentially under an incorrect view of the law, which was corrected by this court in Epic 1. I mean, that's the whole point, as I take it, of the Epic 1 decision and its discussion of punitive damages. It said a few things. First of all, it came back in and essentially disagreed.
It said a few things that it then took back. It said, among other things, that the antitrust laws are unconstitutional because they provide for treble damages. All of that language was rescinded. I hope you're not relying on it.
I'm not. My point is that the district judge and clearly the jury had a different view about the egregiousness of TCS's conduct and how to think about the alleged harm in this case. In Epic 1, this court very clearly said that was the wrong way to look at it. There's important discussion about how the harm proven was minuscule at most. If we're talking about actual harm, it was the cost of investigation. It wasn't this much more grandiose number that really looked at potential harm. And this court also said that, yes, the conduct was inappropriate. We don't dispute that, and we're not relitigating that issue. But it also said it wasn't outrageous. It wasn't egregious. That all affected essentially a reset of how to think about the facts going forward in the case.
I want to ask you a question about that, a line drawing question. Where would you draw the line on whether a remand involves a mechanical calculation? Like a subset of that would be, do you believe this court's decision in Devane 2, which adjusted the attorney's fee award on appeal, was that merely mechanical?
No. The Devane 2 decision that cut the attorney's fee award from $500,000 to $350,000 was not mechanical because it was correcting the legal principles that applied to the court's determination of what that award was. It wasn't just mechanical because it involved the application of new legal principles to the facts and a reassessment of the number. A mechanical application would be something like, really, we'll go all the way back to 1891, the Neelan case that my friend on the other side is referencing. That's a situation where you had a judgment that essentially reflected a formula for how to calculate amounts due to certain interveners, and it involved a rate and a year, and the court came in and said, no, this is miscalculated. You kick out this line item, these few line items, and you think about the years a little bit differently. You essentially remove some portion of a year. That's your judgment. That's a mechanical calculation. That's applying a formula to get to a fixed sum where there's nothing for the lower courts to do. That's not this case. This case is a situation where Epic 1 changed the legal principles that applied to the case and applied to the way the district judge was supposed to think about punitive damages, and it remanded for the district judge to do that analysis. My friend on the other side said there was no discretion for the district judge to reduce the award further. That is incorrect. It's both inconsistent with the wording of the Epic 1 panel opinion that said, think about this again. You can go up to at most 140 million, but you've got to reassess this. And importantly, and this picks up on something Your Honor was referencing, Judge Brennan, that's how Judge Conley understood it too. Judge Conley understood that to be his instructions on remand. He describes that in the order that's subject to review right now. And he himself, who is eminently familiar with the procedural history of the case and knew it backwards and forward, he himself did not think that the punitive damages were meaningfully ascertained until he did that analysis and entered the judgment in 2022. Stepping back to just pick up on a few other points, to answer your question about whether there's any daylight between Devane and Harris, I don't think that there is. I didn't understand the answer from my friend on the other side. In both cases, what you had was the vacatur of an earlier judgment or award. It gets remanded for reconsideration. It's not just a mechanical calculation. And in both cases, this court says you run the post-judgment interest from the later judgment on remand.
How are we to deal with all this other out-of-circuit case law that goes the other way?
So two comments there. One, I think it's easy to distinguish that because this is a very unique procedural posture where you had the articulation of new legal principles in Epic 1 and a remand to the district judge to consider it anew. The other cases they talk about from the 11th Circuit and from other circuits didn't have that kind of open-ended remand where the district judge was applying newly articulated legal principles to facts that essentially had been adjusted by the Court of Appeals panel. So that's number one. Number two, I don't think you need to take this on, but I do think a lot of those cases run contrary to the plain meaning of the statutory language and are inconsistent with the Supreme Court's decision in Kaiser Aluminum, which said very clearly, don't do equity. We apply the plain meaning of the language, and the plain meaning of the language says you look at the judgment where the plaintiff is seeking execution. That's the judgment in this case. That was part of the discussion where the court said the lower courts applying equity had been running the judgment to the verdict and said look at the judgment. Thank you, Your Honor.
You have 10 seconds. How fast can you talk?
Will you
8 seconds, sorry.
allow me to attempt to make 3 quick points?
Depends on how fast you can talk.
The plain language argument must be wrong. Kaiser would have said in post-judgment interest runs from the latest judgment. Vacater, Exxon, Johansson, and Dunn involved fully vacated judgments. And 3, the scope of the remand arguments have been rejected by this court and they don't matter. And for those reasons, we respectfully request this court run post-judgment interest from the earlier judgment.
Thank you very much. The case is taken under advisement. We'll hear argument now in the case of Oy against Hartford Life and Accident Insurance Company. Mr. Dubofsky.
Good morning, and may it please the court. My name is Mark Dubofsky. I represent the plaintiff appellant, Olayinka Oy. The district court opinion rendered in this matter was not plausible in light of the record viewed in its entirety, and was therefore plainly erroneous, or clearly erroneous rather, for at least 5 reasons. 1, the district court viewed the benefit termination decision in a vacuum, ignoring prior findings made by Hartford and relying on discredited evidence such as the 2016 functional capacity evaluation. 2, the court discredited Ms. Oy's doctors without justification, even though Hartford had previously deemed such evidence reliable and their records were comparable to the same wording in medical reports that this court found credible in Sarche, Hawkins, and Kennedy. The other consideration is that the court apparently did not recognize that fibromyalgia does not produce laboratory findings that would be indicative of a musculoskeletal impairment or a neurological impairment. And the one objective finding, the trigger points, was found throughout the records by the physicians at Northwestern University. 3rd, the district court focused on sedentary physical capacity but ignored the other aspects of Ms. Oy's position, which was highly cognitive. This court ruled in 2 prior cases, Lacko and Scanlon, that it's not enough to consider the physical aspects of a job, but the cognitive aspects of the job also have to be taken into consideration. The court failed to address at all whether Ms. Oy could perform complex mental tasks and travel extensively or do any kind of meaningful work while suffering from the pain and fatigue that is recounted throughout the records, not only by Ms. Oy to her physicians, but the witness statements that were submitted as part of the record. 4th, the district court ignored Hartford's consultant's patent bias against fibromyalgia. The reports that were issued by Hartford's consultants all showed an apparent bias against fibromyalgia or ignorance. The first report, Dr. Clinton, considered conditions other than fibromyalgia. There was no contention that there were any other disabling conditions other than fibromyalgia. Dr. Singh, who purports to be a rheumatologist, stated that fibromyalgia is not a rheumatic disease, even though this court found in Sarche versus Chater that it is a rheumatic disease, and the American College of Rheumatology says the same. And the other doctor, Dr. Fung, who recognized that the complaints of pain and fatigue were consistent throughout the record, his problem was that there were no objective physical findings other than the trigger points, which of course in Preston versus HHS from the Sixth Circuit, as well as this court's decisions in Sarche, Hawkins, and Kennedy, say just the opposite. And finally, the district court opinion made no reference whatsoever to this court's precedents regarding fibromyalgia. There is not a word in the lower court's decision about Sarche, Hawkins, Chater, Holmstrom, which dealt with the issue of pain, Scanlon, Lacko, none of those cases were cited. In other words, the court issued a decision in a complete vacuum. Now, we acknowledge that the court's obligation was to issue an independent decision. This was an ERISA case decided under the de novo standard of review, meaning what happened before the plan administrator was not necessarily relevant. We agree with that, but there has to be some consideration based on the Ledger versus Tribune case of the history of this claim. Ms. Oy was found disabled by Hartford in 2017 based on Hartford's own consultant's opinion, Dr. Levin. There is no mention of Dr. Levin in the district court's opinion. There's no mention of Dr. Levin in Hartford's briefing. But Dr. Levin's report was deemed valid when it was issued in 2017 and dictated the initial approval of the benefit claim. Dr. Levin's report was cited again twice in 2018, and in 2019, when Hartford performed a special investigations unit investigation of Ms. Oy's entitlement to benefits, yet again, Hartford determined there were no material inconsistencies and the pain complaints were supported.
So, Mr. Dabowski, this is the point on which I get a little bit confused, because you say you acknowledge that the district court's review was to be independent, or de novo, as we love to say, that way. Okay, but at the same time, you say it was error not to consider the claim history. Those two things seem at odds with themselves, because I don't know what you mean by the point about Dr. Levin, I get. I've got a question for Hartford about that. Okay, I understand that. But a failure to consider Dr. Levin's views is different than some sort of, like, I don't know, estoppel or claim preclusion flavor to this business about you had to consider the claim history. So I'm not sure what you're saying. In other words, it seems like it's in tension with itself.
So I acknowledge the mental gymnastics in this case, and they are confusing. But the point that I'm trying to drive home is that while Judge Chang was free to make an independent decision, in fact, it was his obligation to do so, he couldn't do it in a vacuum. He couldn't do it without considering the entirety of the evidentiary record. He couldn't do it without considering this court's precedents.
Okay, now that's fair, because if what you're saying is that the legal error, for example, among others, was a complete omission of any consideration of Dr. Levin's views, okay, that's different than saying that he owed some kind of deference, or Hartford's prior administrative rulings, stopped him or something. You're not using those words. Those are my words. But
right.
There's a flavor of your argument that kind of sounds in that.
I acknowledge what Your Honor is saying. And again, I go back to the mental gymnastics can be a little bit confusing, which is why I reiterated the point that I was trying to drive home.
Yeah, I mean, I'm not faulting you for relying upon claim history. I mean, that is something that is, they were the ones that decided, I don't know why, I couldn't figure that out, but they decided to reevaluate her claim.
And the other factor is that a key component of Judge Chang's decision was the 2016 functional capacity evaluation, which Hartford had previously rejected. And while the 2016 FCE was given to Hartford's consultants, they didn't give Dr. Levin's report. They didn't give some of the other evidence to the consultants.
It seems like what you're saying in advocating for your client is, look, don't lose track of the kind of context and atmosphere of this. She's kind of whipsawed, is what you're saying.
Precisely.
I got it.
So at risk of losing my, or I guess I still have a little bit of time. And the last point that I want to make is that the outcome of this case should be a restoration of Ms. Oi's benefits and not a remand. The status quo prior to the termination of benefits was the payment of benefits for 3 years. I acknowledge that there has been an intervening event. The change in definition from the any occupation to the own occupation standard, and I acknowledge the Pakovich decision from this court. But this record is so clear-cut that Ms. Oi's condition is permanent based on Hartford's own consultant's opinions and the Social Security finding that she can't do anything, and the reality that somebody who is that racked in pain and fatigue would not be able to perform any type of a meaningful job, nonetheless a job that would pay her close to $100,000 a year based on the policy terms, should be awarded benefits retroactive to when the benefits were terminated in 2020 and brought up to the present. Thank you. I'll reserve the rest of my time.
Ms. Herring.
Thank you, Your Honor. May it please the court, Jacqueline Herring on behalf of Hartford Life and Accident Insurance Company. In this case, the district court did exactly what the district court is supposed to do. The district court weighed the evidence, made credibility findings, and entered an independent decision as to Ms. Oi's claim for benefits. The district court decided adversely to Ms. Oi. She disagrees with that, but that's not clear error as required to reverse the district court's opinion. A lot of the questions that were raised in counsel's initial argument, yes, the entire argument is really an attempt to create burden-shifting presumptions. Hartford did something in the past, so the district court, rather than being independent, must somehow be bound by that or overcome a presumption that what Hartford did in the past is what the district court's required to do. And what's interesting is if we had the exact reverse, if we were arguing, well, Hartford denied the claim, so the judge should certainly deny the claim now because that's what Hartford did before, that argument goes nowhere. And Ms. Oi's argument, for the same reasons, goes nowhere. This is an independent decision, and the case law is very, very clear that what the district court is supposed to do is make an independent decision, not look at what was or was not done in the past. There was no evidence that was, quote, discredited. Nobody ever discredited the FCE. Hartford weighed it differently back then than the district court did in making its independent decision.
District court made a very thorough opinion here. Was the district court required to at least briefly state why it found Dr. Levin's report unpersuasive or mention Dr. Levin? It seems to be one of the stronger arguments that the appellants offered.
And I think the problem with going down that road is then we set a standard whereby under Rule 52, if a district court doesn't address absolutely every single piece of evidence in the record, then the district court has created a clear error. And that's problematic, because then the next time we're here, it's, well, there was that one medical record from 2015, judge didn't rebut it in his Rule 52 opinion, therefore he's committed a clear error. And again, you know, the law is clear under Rule 52 that the judge does not need to address every single piece of evidence. What the judge needs to do is lay out the reasoning for what the decision was. And the district court did that very clearly here, and what the district court did was plausible. Expert opinions that have detail.
So I don't think you're going to, I think you're on solid ground saying we're not going to impose an opinion writing requirement where you have to, like, you know, chronologically type in the medical record or something like that. But the point that Mr. Dabowski's making is that, and going to Judge Brennan's question, is that the omission of any discussion of Dr. Mark Levin's prior view is pretty material here. So how do you respond to that? Forget the whole opinion writing business. It's a material omission is the point that your adversary is making.
And I think, again, anything can be taken as a material omission if a party thinks it's something that supports their case that the district judge doesn't address. But I think what's more important is that what the district court was looking at is at the time the claim closed in September 2020, what does the evidence tell us? And all three of the physicians consulted by Hartford that the district court found detailed and persuasive.
So is that another way of
addressed
saying Levin
improvement.
goes back? Levin's view goes back to what, like 16 or something?
2017.
2017.
Yes, and Dr. Fung, Dr. Clinton, Dr. Singe, they were all specifically asked, because of counsel's criticisms during the administrative process, they were specifically asked, is there any evidence of improvement? Has anything changed since 2017? And all three of them pointed to specific information in the record, documented medical findings that showed improvement. And those were detailed in each of those reports. And I think that's one of the reasons that the district court found those reports persuasive. They went through some of the chronology for the district court, went through what the findings were, addressed specific questions like what's different from 2017 now to 2020. And so those questions were answered, but to require again that the district court essentially rebut everything that's in the record, again, is that burden shifting presumption that we're looking at here. And I think a lot of this stems from, we're usually here on, or we used to be years ago, on arbitrary and capricious cases, where it is all about what did Hartford do, what didn't Hartford do, did Hartford do the right thing? And that's now being imposed on the district judge. If Hartford did this, the district court has to do that as well. If Hartford didn't rely on that 2016 FCE, the district court is somehow precluded from considering it, even though the district judge is charged with making an independent decision, and that 2016 FCE is in the record. And in addition to the actual physical findings from that FCE, there were a couple other significant points in that FCE that impacted the district court's finding. And some of that was that her physical complaints were just not consistent with the evidence. There was considerable question as to reliability and accuracy of pain reports. And yet her entire case relies on the credibility of her pain reports. In counsel's argument, again, there was this discussion of, well, fibromyalgia, it's not going to have all these other things, and you're not going to see various findings. But the distinction is, we're not talking about what's required to diagnose fibromyalgia. We're talking about functional impairment resulting in disability. So the absence of physical findings of, for example, if someone is truly so disabled that they're virtually bedridden, which is something that she has claimed, you would expect there would be some atrophy. Perhaps some lack of mobility in joints. You would expect to see functional and physical findings that were showing that impairment and disability. And this court has said a number of times that although pain itself can't be measured, the functional impact of pain can be. That's what the FCE did, and that's what the reference to the various physical findings are about. Are we seeing a physical manifestation of an impairment that would preclude occupational duties? That's what the physical findings are about. Not does she or does she not have fibromyalgia based on trigger points. That's a non-issue. Whether she does or does not have fibromyalgia doesn't qualify her for benefits under the plan. She has to have functional impairment. And the district court very clearly marched through which opinions were persuasive, which were not. And the district court also alternatively found that her mental conditions were clearly a causative factor here. And the plan limits to 24 months conditions that are based on mental impairments. And it doesn't matter whether those mental impairments resulted from something underlying physical, whether those mental impairments are resulting in physical manifestations. The point is, if there is a mental illness that is creating the disability, then that's capped at 24 months and no more benefits are payable. And again, the district court went through very clearly what the evidence was of that. Virtually
So is your point with that she was paid for that period of time and therefore she can't be disabled beyond that period of time?
That is correct. And also, as the district court pointed out, Ms. Oy specifically said, you cannot consider any of my mental conditions. Well, and we see more and more claimants doing that because then they can withhold records that might shed some light on what the actual condition is. And so what the district court found was, then what you're telling me is I need to base solely on fibromyalgia. Have you proven to me that you cannot do your job? The district court said no. That finding is plausible based on the record, was not clearly erroneous, and should be affirmed.
Thank you, counsel. Anything further, Mr. Dubofsky?
The problem with Ms. Herring's mental impairment argument is that Hartford never claimed that Ms. Oy was suffering from a mental impairment. They never notified Ms. Oy that her benefits would be limited on account of that. And in fact, Dr. Levin said, and I quote, Ms. Oy's pain and cognitive issues play a major role as to her psychiatric and psychological issues. The treating psychiatrist, Dr. Albahari...
Yes, I don't think recitation of the evidence is helpful. Thank you, counsel.
Thank you, Your Honor.
Case is taken under advisement, and our final case of the day is United States against Morales. Mr. Tennant.
Good morning, Your Honors. May it please the court, counsel, my name is Bill Stanton, and I represent Eduardo Santana. In this appeal, Mr. Santana challenges the sufficiency of the evidence to convict him of participating in a drug conspiracy, as well as the denial of a minor role reduction at sentencing. The facts in brief are that Santana's co-defendant, Mr. Morales, was plugged in with some drug brokers and was trying to obtain some distribution quantities of narcotics. The government had a tap on Morales' phone and intercepted several phone communications, most of which were in code. My client, at Mr. Morales' behest, served as a translator on some of those phone calls. and he also kicked an empty box on a porch at Morales' bidding. Agents, over the course of this 7-month investigation, intercepted quantities of methamphetamine, cocaine, and fentanyl, and from that 7-month investigation, it was shown that Santana was involved for mere weeks of that. As it relates to the sufficiency of the evidence, admittedly, we have an uphill battle, but we're going to plot ahead. The evidence that there was a conspiratorial agreement here is paltry. The evidence was that Morales and Santana were lifelong friends, that Santana served as a translator on these phone calls as a favor to his friend and not as part of some conspiracy that he unknowingly joined. There was no intention to further the conspiracy, and I think the intercepted communications plainly illustrate that. You have conversations where Santana and Morales are talking, and Morales is talking about they want us to open up a Chicago office, they being drug suppliers from a foreign country. Santana's response is, well, what office building would we use? He didn't know what he was talking about. Another example would be in a kind of a Ralph Cramden-esque saying that in a different context, we're going to go to the moon with this. And my client said, okay. No real grasp or concept of what the co-defendant was talking about. But it was Morales who was the one with the connections. Morales was the one that was coordinating these calls. And my client, who spoke Spanish, would simply translate as Morales asked him to do.
Wasn't there some discussion between the two about ripping the guy off?
There was a discussion about, between my client and the co-defendant,
take the drugs out of the box when the box gets here and then call this Omar fella and tell him it came empty?
Exactly. It was, I don't know if they had watched too many movies, but some type of repackage the box with just packing peanuts or something and pretend that the box had been opened. And confusingly enough, one of the boxes in this case had been delivered empty with a postal inspector's business card inside of it.
Yeah, the only reason I'm raising it, Mr. Stanton, is that at least as I, reviewed this, it looks like he's more than a translator. He seems well aware that Omar's shipping, drugs, not widgets or something, and the guy's getting the drugs and distributing them around here, and then they have this idea, well, maybe we can rip him off. We can kind of do this little, fooling with these empty boxes.
But I guess I'd counter
he's
that.
Not just a Spanish interpreter.
Is his awareness in and of itself akin to joining the conspiracy? Is he trying to profit from the conspiracy? Is he trying to understand the scope of the conspiracy? Is he making any decisions that would further the conspiracy? And my answer to those questions would be no. Because even if you review the phone calls before Omar, or before the prisoners are on the line, Morales instructs Santana, you say what I tell you to say and nothing more, I can find a new translator. So basically he was very limited in what he wanted my client to do, is just translate word for word and don't add anything, don't take anything away. So as it relates to the sufficiency of the evidence, I would say that the government had to prove three things here: that a conspiracy existed, that my client agreed to join that conspiracy, and that an act in furtherance was done for that conspiracy. And I think the second element here, the agreement to join, simply was lacking. If there's no questions on the sufficiency of the evidence, I'll move on to the minor role reduction argument. It's our position that the district court clearly erred here in denying a minor role reduction under guideline section 3B 1.2b. And the factors that a court should consider in applying this reduction are the knowledge of the scope of the conspiracy, whether an individual served to make a financial gain from the conspiracy, and the individual's planning and or decision making throughout the conspiracy. Here we have Morales, who was the one giving the directions. Morales was the one with all the discretion, and Santana really had no discretion. So it's our position that Santana was less culpable than most of the other participants in this conspiracy, namely Morales, as well as the 3 or 4 drug brokers that were on these phone calls, and that the 2-point reduction should in fact have been awarded by the district court. If there's no other questions, I'll reserve the rest for rebuttal.
Thank you.
Thank you.
Certainly, Mr. Stanton. Ms. Greenwell.
Good late morning, Your Honors. The evidence here was something the jury said, yes, he was guilty of and did join the conspiracy for. And that evidence was more than ample. Because I would start with just, not only was he more than a translator in the sense that, as Judge Scudder pointed out, he gave advice to the defendant, and not only about how he could rip off or get compensation for not paying for drugs from Omar, but also, you know, that they should change phones so they weren't detected by law enforcement, so that they could deal with Susie in some retaliatory fashion for maybe giving them up. But also, I just think you need to look at the incident that defense counsel refers to as just kicking a box, because to me that said a lot of it, because he didn't just kick a box, right? He went there to protect Morales so that Morales wouldn't be the one in the center of things, well, because they believe at the time law enforcement's there, so he volunteers to go. He films it, and then after filming it to be able to prove to Omar that it is empty, he goes and he pleads with Omar, pleads with him on the life of his children that this box is in fact empty. And he's doing all that because he shares Morales' interest in satisfying this supplier and making it clear that they're not just ripping him off and lying about there being no drugs. And he's also showing his interest in making sure these drugs get delivered, get picked up safely. And that's just one example, and then we list in our brief all the others. And as well as that he's being compensated for this. And as well as this isn't just something he's involved in for mere weeks, because from the beginning of The Wire, Morales is talking about having given a kilo to Santana for what he did, all the way through to the end. And particularly when Santana shows that he knows where these drugs are being delivered from the beginning. So all of that's detailed in our brief. And I think it goes to show, not only, as the jury did, goes to show that he had the requisite knowledge and intent, and it also goes to support the judge's finding as not being clearly erroneous that he was not a minor participant.
Ms. Greenwald, can I ask you just a kind of a factual, clear something up for me question?
Of course.
Okay. There's a bunch of back and forth in the briefs about at least 2 people that were in jail that had some role, I think, in connecting the co-defendant Morales to this Omar guy. They were middlemen or intermediaries, or
Yes.
they're characterized that way. Is any of that of significance for purposes of evaluating the sufficiency of the evidence to support the 846 conspiracy conviction? And the reason I ask the question is, when I went back and looked at the indictment and, you know, reviewed the way the evidence was presented and you all briefed it, it seems to me that your position, you can correct me if I'm wrong, is that, no, that's kind of part of the case and part of the evidence and part of the context, but it's neither here nor there for purposes of sufficiency on the 846 conviction, because the 846 conviction can root itself alone in an agreement between the 2 co-defendants.
Absolutely.
These middlemen, intermediaries, however we prefer to characterize them, they don't have anything to do with it.
I would agree. The reason it was part of the evidence and part of the developing of the evidence, it became important in terms of the judge's analysis on the whole buyer-seller thing, which was a Morales issue. It was never a Santana issue. So it became relevant to the judge's analysis of that whole issue and addressing that. Had the jury not found a conspiracy between Santana and Morales, you know, was there a buyer-owned relationship with the others?
Okay, I
understand. So that's
that.
where it became. But as to Santana, 100% you are correct, Your Honor. And I would maintain now on appeal, that's true as to Morales too, but he doesn't raise sufficiency and isn't at issue here today with us. If there are no more questions, the government respectfully requests that you, on the basis of our brief and today's argument, affirm Defendant Santana's conviction and sentence.
Thank you.
Thank you very much. Anything further, Mr. Stanton?
Very briefly, thank you. I'd like to address the expectation that Mr. Santana expected a kilo payment for his activities, because something that I learned is that during the course of these conversations, he said, I hope to get it along the lines of, I hope to get a Powie. I don't understand what Powie means, but the agent clarified that that's just a small bag of powder cocaine, that he was hoping payment of a user amount of cocaine. So I think any suggestion that there was a kilogram payment waiting for him is belied by that statement. As far as the two men in jail, I think that lends to the analysis, though, of the minor role reduction that we were advocating for, because their active brokering from a jail cell on a contraband cell phone, I think rises to the level of participation that is much more significant than passive translating. So with that, if there's no more questions, I thank you for your time and ask that you grant the relief we're requesting.
Thank you.
Thank you, Mr. Stanton. The court appreciates your willingness to accept the appointment in this case and your aid to the court as well as your client. The case is taken under advisement and the court will be in recess.